How do I update or change my will in Georgia? Hi, I'm estate planning and probate attorney Zach Beck with Peach State Wills and Trust here in Lawrenceville, Georgia, and we'll answer that question in today's video. So, how do you update or change your will here in Georgia? Well, let's start with what you absolutely should not ever do. You shouldn't just pick up the will that you have with a pen or a pencil and start crossing things out and writing new stuff in. You might think, oh, but I'll initial and sign next to that change on that page and that'll make it valid. You'd be wrong. By marking up a will like that, you risk invalidating part, if not all, of the document, as there's clear evidence from the fact that you marked it up that you intended to revoke at least part of that will. So what we don't want to do is just pick up that pen and start crossing things out and writing new stuff in, because those changes weren't witnessed with the same formality that your will originally was. So what do you do instead? How should you go about changing your will? Well, you've got a couple of options. First, you can make what's called a codicil. This is a fancy legal term, but basically it's an amendment to the will. You can add distributions, change recipients of things, change executors, or really anything you could have done in making a will itself. A codicil should be signed and witnessed with the exact same formality as the will. And then your executed codicil should be stored with the will. While there's nothing inherently wrong with doing a codicil and changing your will with this approach, it does present a few possible issues. First, when you execute a codicil, nothing on the face of your original will, which is still at least partially valid, indicates that the codicil exists. So if your codicil ever becomes lost, either intentionally by some nefarious actor or unintentionally, your executor, the court, and your loved ones may never know that you intended to update your wishes as you expressed in your original will. Second, codicils can sometimes be confusing for your executors and loved ones to understand your intention, as they can completely change sections of the will and completely change those distribution schemes, who's in charge, things like that. And because nothing on the will says that that's been changed, your executor and your loved ones may be confused as to which sections are still operable and which have been superseded. The alternative to creating a codicil is to create an entirely new will, which incorporates your new wishes. This approach is often preferred for a couple of reasons. First, like we talked about with the codicil, there's less likelihood for confusion, as no one will need to cross-reference multiple documents to understand and interpret your wishes. Second, by executing a wholly new will, it may be less likely for pages to be lost, or at least plainly obvious if a page is lost. Since the pages in your new will would skip from, say, page 5 to page 7, it'd be obvious that one was lost if it was. So now that we've talked about how to update or change your will, we need to talk about when you should update or change your will. So your will doesn't necessarily need to be updated just because things have changed in your life. Oftentimes, wills have built-in plans for what happens in responses to those life change. However, that built-in plan that your will had may no longer match the wishes that you have now after that life change has occurred. So generally, we recommend at least reviewing your plan in response to any of the following life changes. If you get married or divorced, or a divorce case has begun, if you have a child, either through birth or adoption, a beneficiary under your will has passed away, a child or another beneficiary has reached adulthood, or any other important life milestone that you were contemplating, like say marriage or age 25, when you originally drafted your will. Persons that you've selected to be your executor, your trustee, your guardians for minor children either pass away, become incapacitated, or your relationship with them just changes to the point that you no longer want them to serve in that role. If your net worth grows substantially, you may want to make some changes if your will didn't already contemplate any kind of federal estate tax or state level estate tax in another state. If you move to a new state or country or acquire real estate in another state or country, we want to make some changes to the will potentially to incorporate your wishes for that property. And lastly, if there's a material change in the law relating to wills, you may need to make some updates to the will to ensure compliance with the new law and to optimize your plan to be administered under that new law. So that's how we go about changing a will and kind of when to think about changing a will. For more information about estate planning, you can contact us on our website, peachstatewills.com, or give us a call at 678-344-5342.